A little bit more on open justice and transparency on the back of sort of my recent videos and things in the news. Because there's an interesting case this week. There'd been a fraud trial, a corruption trial. Two guys were on trial for sort of bribing people in Saudi Arabia for contracts. Their defence was quite interesting because their defence was, well, the government were in on it. They were facilitating our our little bit of backsheesh sort of inducements. And this trial caught the attention of two organisations, the Guardian newspaper and also a group called Spotlight on Corruption. And Spotlight on Corruption, as the name suggests, they're sort of a lobby group, a pressure group. That they investigate these sorts of things. Now, is there any difference between a sort of a pressure group and a newspaper? Well, the court will come on to that shortly. But what did they want? Well, they said, look, we would like, because we want to report on this, we would like copies of opening and closing speeches from counsel, skeleton arguments, copy of the indictment, transcripts of the proceedings, but we'd also like, please, the jury bundle. Now, this is a prosecution by the Serious Fraud Office, and initially they said, yeah, no problem, we'll get all that to you. It might have to wait until after the verdicts, but we'll definitely get that to you. However, they then sent a subsequent email saying, oh, hang on, we're not sure about this. We think we might need the court's permission to give you this. We're not sure we can hand it over. Spotlight on Corruption, the Guardian said, well, we think that's wrong. We think you can do it. But OK, we're happy. We'll just make an application to the judge. So they went to the judge, and the judge took the opportunity, effectively, to go through both the rules, the criminal procedure rules and the practice directions, and also the authorities, just to clarify this for future use. And I just thought you might find it, sort of, as always, vaguely interesting. Because the email, the application said, we consider that the documents are necessary both for a full and proper understanding of the reporting of the case. The case is highly complex, spans several decades, involves arcane terminology, and is heavily reliant upon contemporaneous documentation. The documents will help to ensure that we have properly understood the case in its totality. Where we can publish certain key exhibits, there was a particular note for instance, this will be made much more comprehensible to the reader than an extended verbal description of what the note may or may not be said to communicate. So their argument was, look, we need all this material to report it accurately, rather than just sort of describe what went on in court. Because when it came to the transcripts, the judge made a very good point. He said, look, there's nothing to stop anybody sitting in court and making a note and then going home and typing it up and putting it on the internet. So, he couldn't logically see why there was no reason just to allow them the transcripts. But this brought another interesting issue up, because the transcripts are provided by private companies. You pay a company, there's a list of ones who are approved transcript companies, and you say, right, I want the transcript, and it could either be, everything that was said that day, or sometimes, if you're doing an appeal or something, you might say, I just want the judge's summing up. But you pay them, and then they give you the transcript. I mean, now there are some actual live stream transcripts where they sort of do it in real time. But again, you still have to pay for those. And, the paper said, we accept we've got to pay for this. But then the issue arose of who owns the copyright in that. Because the companies, when you actually sign up to this, they say, yeah, we will provide you for this, but it's for your own use and your own legal use, and you mustn't publish it anywhere. And what the court actually said, because I'll cut to the chase, I mean, like I say, you can probably see that the judge was leaning towards, yes, you can have everything you're asking for, but I'll just explain, why, so in future people aren't making unnecessary applications. And said there, well, yeah, look, we can't really stop you putting this up, notwithstanding what the contract says. Because, is there really any copyright in it? And they said, if there is any copyright in this, well, arguably it belongs to the court service, and we give you a license to use this. It's a non-exclusive license, and you can't sub-license it. But they said, yeah, once you've paid for a transcript and you've got it, you can pretty much do what you want with it, except sell it to somebody else. You can't profit on the back of it. But, with regards to the materials, like I said, they said, okay, there might be certain reporting restrictions. Sometimes there are, good reasons for, keeping some information quiet because there might be vulnerable witnesses. In a lot of cases, there's confidential private information. Especially in financial cases, it's sort of commercially sensitive information. I mean, like I said, there's nothing to stop somebody sitting in court and scribbling that down. But then they can put reporting restrictions in place and say, you don't need to go into the details of that. I mean, to give an example, say, for instance, there'd been a bank robbery. It's quite common in that where they'll explain how their security works. Oh, well, we film these people on a hidden CCTV camera here and we have these procedures in place to track people down. They don't really want that publicising. So next time, the next person robbing the bank goes, oh, right, now I know where all the cameras are and where the pressure pads are and where their alarm system is located. So they'll say you can't put that in. Sometimes, like I've said, if there's, covert observation and they're using somebody's premises, it'll be you don't have to identify the premises so that people can't track down, the owners who allowed the police to use them in case there are reprisals. But they said the starting position is, because you actually do this through the court office, you write to the court office and say, I want this material. And what they've said there is that the court officer should go from the starting position that actually, yes, they can probably have all this material, but if you're not sure, just refer it back to the judge. But the starting position is, yes, people are entitled to this. And they said, and this is where we come into the distinction between sort of proper journalists, traditional media, citizen journalists and just members of the public. And what they said there is, if somebody's like an accredited journalist, they've got the press card or they've got a letter from their editor, well, that should show like a higher interest in releasing it, because then you can assume that the people who you're releasing it to, they will use this responsibly. They'll be aware of all the rules about contempt of court. Because they actually put that in the application email. They said, look, we're totally on board. We know what contempt of court is. We know what the strict liability rule is. Because there was an issue here as to if there was a hung jury, there might be a retrial. And they accepted in the email, they said, we want this material in advance so we can start working on the story in case they're convicted. But we accept that if there is a retrial, because actually that would have been the third retrial, because this case was actually the second attempt at it. They said we accept that the only thing we could really publish there would be the indictment to say this is what they're charged with. We couldn't do anything else. So they were acting very responsibly. And the court said we can sort of assume that accredited journalists act responsibly. But they also said, well, I can't see any difference for pressure groups. Just because somebody's not like traditional mainstream old-style media, well, why should they be treated any differently? Because they said the starting point is just regular members of the public can do this. You don't have to show a good reason for wanting this material. You might just be nosy. So you're perfectly entitled to go along and say, oh, that was an interesting case. I'd just like to read a bit more about it. And it's like, yeah, we've got to hand everything over to you. So that was the sort of starting point. And, I'll just go through some of the interesting things that sort of came up. Because like I said, in the guidance it actually says, the court officer and the court must have regard to the importance of dealing with criminal cases in public, allowing a public hearing to be reported to the public, but also the rights of a person affected by the direction or order or a warrant issued by the court to understand why that decision was made. Because that was the other thing they asked for. They said, we'd like to be able to report on any decisions made in the case about, say, the admissibility of evidence or things like that, because they said it'll just help the public understand how these trials happen. And one thing they actually raised was, they said the problem with these big complex trials is they tend to go under the radar because, they're very long cases. A lot of the evidence is very tedious and technical. And they said the problem is these are underreported because people go, I'm not sending somebody down to court for 10 weeks to sit through and make notes. And in the absence of this material, it's very hard to then write the story. They said, but if you give us all this, we can rather than have to sit in court every day, we can just publish a story based on this, and we want to get it right, so we'd like to see the transcripts. Because, I must confess, I hadn't heard of this case. And the judge would say, this is a very, very important case and very serious. I literally hadn't heard of it. Although one thing that's interesting is it turns out one of my old friends, Graham Brodie, KC now, I didn't know that. He was actually acting for one of the parties. I've not seen him for donkey's years. One of my old drinking buddies. But yeah, there's something called the overarching principle when it comes to this. And they said the general principle is that the administration of justice must be done in public. The public and the media have a right to attend all court hearings, and the media is able to report these proceedings fully and contemporaneously. Because that was the other thing. They said, we want to be able to do this in real time and report what's said every day. And this is where you do get into a bit of an issue, because when you're reporting in real time, obviously, at the start of the case, you're just hearing the prosecution case, and then, might not hear the defence later. If the case gets kicked out, or, a successful half-time submission of no case to answer, that might be the end of it. But do people really get a good understanding of what's going on? But they're saying that's just a risk that people have to take. When you're reporting contemporaneously, theoretically, there's nothing to stop you reporting just on the prosecution case and then not reporting anymore. So, anybody looking through your archives will probably get a one-sided view of that case. But if you're reporting afterwards, you have to report fair and accurately. So you have to say, well, this was all the evidence that came out, and this is what the prosecution said, and this is what the allegations were. But at the end of the day, they were acquitted. And you'd have to put that. And what you tend to find now, that everything's online and archived. It's not like the old days where you'd have to root into what they used to call the morgue, where they kept all the old newspapers and physically read through them. Of course, now you can just Google or look at their website and find old articles. And sometimes they will actually update them. They'll put like a little one line saying, ultimately this person was acquitted, or something like that, just to cover themselves, because then you get into all sorts of issues about defamation. But yes, it says, where an application is made by a reporter, the general principle is that the court should supply documents and information unless A, there is a good reason not to, in order to protect the rights or legitimate interests of others, and or B, the request will not place an undue burden on the court. Sort of going, that can be something where it's like, we'd like the jury bundles, or we'd like all the evidence that was in this, and there's tens of thousands of pages. It's, well, who's going to pay for the photocopying on that? So, that can be a reason. And it also goes on and says, the supply of information is at the discretion of the court, but it explains that where documents have been placed before the court or read aloud in its entirety or deployed at trial, these should usually be provided on request. It also explains that the court should consider, prior to providing a copy of the jury bundle and exhibits, whether access to the documents is necessary to understand or report the case. And then it goes into the privacy of third parties, reporting restrictions, risks to prejudice a fair trial in other cases, things like that. The same table actually suggests that transcripts of hearings in open court can be obtained for a fee from the transcription service provider, which is true. And like I say, you get back into all that copyright thing. But when it comes to saying if this material necessary, well, who gets to decide whether it's necessary to report the story? Well, again, the authorities and the rules are quite strict there. They, quite clear there. They say judges aren't editors. Judges must not exercise an editorial judgment about the, quote, adequacy of the material already available to the paper for its journalistic purposes, unquote. The responsibility for complying with any and all restrictions on the use of the material rests with the recipient. And it says, statutory restrictions prohibit publication to the public at large or any section of the public, or some comparable formulation. They do not ordinarily include prohibit publication constituted only of the supply of the transcripts to an individual applicant. However, any reporting restrictions will continue to apply to the recipient of the transcript. But what they're saying there is, it's not for the court to say you don't need this material, or it doesn't help you, or you can get this material from elsewhere, or you could have made a note. It's for the recipient, the person who wants to publish this, to say, I know best what material I want. And they've just said, just remind them then of the reporting restrictions, but you just basically have to trust them. So there you go. I'll publish a link to this judgment in the description because it goes into lots of detail. It does lots of quotes from the old cases, and I know you all like those about, lots of stuff from old judges about, the common law, it's always been, justice must not just be done, it must be seen to be done, and all that sort of thing. Some quite nice old quotes in there, but I won't just read them out. Because in summary, it's clarified what we all sort of knew anyway. But there probably had been some misunderstanding. Like I say, I don't think the Serious Fraud Office were trying to pull a fast one there, because they'd have been very cooperative, saying, yeah, of course you can have all this. And I think somebody just panicked and said, oh, hang on, are we allowed to hand this over? But, they didn't oppose this. They said to the judge, we're happy to give this, but we just want your permission to do it. So there you go. So if you do want anything, And like I say, it pretty much included absolutely everything. Copies of skeleton arguments, any judgments the judges made during the trial, all the documents, the indictments, witness statements, exhibits, and indeed the jury bundle. You can just write to the court office and say, we'd like copies of all this, please. I mean, they might charge you a copying fee. And when it comes to transcripts, yes, anybody... you fill out a form saying, you know, you want the transcript, but the judge has said, generally speaking, because that is the one thing where you do need the permission of the court, say, can I order the transcript? They said the permission should be freely given. So yeah, for all you citizen journalists out there, I'd like to say the court was very clear that they said, look, okay, you know, if people are accredited, but the thing with accredited journalism is, I mean, some of the best journalists in the country, some of the most famous, aren't accredited, because all it means is you've done certain courses. You know, you pay some money, go on a course to go, you're now an accredited journalist. So anybody can go on one of those courses, you know, pay the fee. But a lot of people haven't. So they said, it's a factor you can take into account when assessing whether to disclose the material. But generally speaking, unless somebody's coming along and you think they've got it for an ulterior motive, you know, they're going to search through and try and identify who the informants were, or they're going to use it to intimidate somebody or harass somebody. They said the starting position is you just hand it over, and if you're not sure if you should hand it over, just refer it back to the judge and let them make the decision. So there you go. As always, hope you found that vaguely useful, vaguely interesting, vaguely accurate, and I shall see you next time. And just to sit there to get a thumbnail. Do the Kubrick stare thing. Quite like that one.